everybody. Thanks for joining us today. We are doing our webinar on probate today. We're talking about the different types of probate, when you need certain ones, and how to figure that out. So today we have our two probate attorneys at Generations Law Group. We have attorney Jillian Fino, and we have attorney Tiffany Kudravetz. I'm going to turn this over to Tiffany and Jillian so that they can get us started on the webinar. Go ahead, guys.
Okay, thank you, Carol. I'm going to go ahead and share my screen. Well, like Carol said, today we're going to be unpacking the probate process. So Jillian and I are going to be talking about the process from start to finish, explain what probate is, a couple of types of probate, and we'll save some time at the end for questions. As with all of our presentations, this is not legal advice. This is just an overview. So if you have any questions about your specific situation or if you need help with the probate process, please reach out to us or to another attorney. This is just a general overview to get you started. Okay, so I'm going to start by giving just a broad overview about what is probate. You've probably heard of the term before if you've talked about wills or trusts. Probate in general is just the court supervised process of administering the estate of someone who's passed away. So it involves court oversight. It's time. There's shorter processes. It could take up to 12 to 18 months. There's a cost involved in probate, but ultimately what a court will do is they'll evaluate a will and to see if it's valid or not, if there was a will. They'll appoint a personal representative, and ultimately the person who's deemed personal representative will be able to distribute assets to the beneficiaries. We'll get into the specifics of probate later on, but there are three main types of probate: formal, informal, and voluntary administration. And formal is the most lengthy, detailed process. Informal is right in the middle, and voluntary administration is probate for very small estates. So Jillian and I will talk through those. And during the conversation today, we'll be talking a lot about a personal representative. And so what is a personal representative? It's a term that you might be familiar with called an executor. But a personal representative is actually the person who is appointed by the court to administer the estate. So when probate first pops up, you're sort of stuck. You can't get access to assets, and there's someone who's supposed to be in charge, and that is the person who's appointed personal representative. Backtracking just a tiny bit in terms of what is probate. A big question that comes up is, well, is probate always needed? And that's a conversation for a whole nother day in terms of avoiding probate or pros and cons of wills versus trust. But one question to think about if you're considering probate for your own estate plan, do I need a trust? Do I need a will? Or if a loved one has passed away and you're looking for the starting point. The question that I would ask you is, are there any assets in the deceased person's name alone? If it's a house that's owned by themselves or a bank account that's owned by that person alone, anything like that where there's no beneficiary or there's no automatic place for assets to go, that's the type of asset that's considered a probate asset. So there are some things that might be probate assets and some might not, but we'll go through a little bit more of that today. To help simplify the process, Generations Law Group has created a probate navigator, and it's a very detailed framework and guide that we give to all of our probate clients that goes through what we consider the three main steps of probate. First is the initial appointment of the personal representative, and so that involves filing the petition and related paperwork with the court. If there's a will, we'll provide that to the court. We have to give them a copy of the death certificate. And basically, we want to get someone situated to go on to step 2, which is administration of the estate. So once the personal representative is appointed, then they can start their task of identifying assets, determining date of death values, paying debts as needed, but basically administering the estate. And then ultimately, the final step is the closing of the estate.
Generations Law Group understands that the probate process can be a complicated journey. That is why we created the Probate Navigator. We have broken down the probate process into 3 phases to inform you of what to expect during this lengthy endeavor. Phase 1 is obtaining the personal representative appointment. The appointment of the personal representative is the first step with the courts in the probate process. This step is important because the personal representative will need the letters of authority to have the legal power to manage the estate, access any assets of the estate, and sign any legal documents related to the estate. Phase 2 is administration. Once the personal representative has been appointed and receives the letters of authority, they are able to begin work administering the estate, gathering assets, paying bills, negotiating settlements, and so on. The steps in Phase 2 ensure that all financial matters and assets of the estate are gathered and properly managed and prepare the estate for the distribution or transfer of assets. Phase 3 is closing of the estate. Once the personal representative has completed all the steps to administer the estate, and after 1 year from the date of death has passed, the probate is ready to officially close. The steps in Phase 3 provide the beneficiaries with critical information about the estate and allow the estate to be officially closed with the courts. Additionally, it allows the personal representative to be released from their duties and sureties on the bond, if any, to be terminated. The probate process is lengthy and complex, but you don't have to go through it alone. Contact us to use the Probate Navigator to guide you through a successful probate journey.
Thank you for that introduction, Tiffany. I'm first going to be discussing formal probate. So what is formal probate? Tiffany touched on this a little bit, but is the most comprehensive of all 3 of the options for probate. This is going to give you a determination from the court that is going to include a formal determination of testacy, a formal determination of the heirs, as well as the devisees. It is really like the gold standard. It's going to give you everything that you could possibly need from the court. However, with that comes a lot of time constraints. It is going to be the most lengthy process of all of them. It is going to take the most amount of time, and it is going to have the most court oversight as well. So when is formal probate needed? There are multiple situations that could call for formal probate, and some of it might just be personal preference, but we generally recommend that formal probate is used when the beneficiaries do not get along or everybody does not agree on moving forward with an informal probate, when could be a potential contest by one of the beneficiaries or heirs, and if any interested party, this could be an heir or a devisee, lacks the legal capacity to make their own decisions or is a minor and is not represented by a court-appointed guardian or conservator. This is different from if someone were to have a power of attorney or a healthcare proxy appointed in a separate document. Those, unfortunately, for court purposes for the probate court, do not qualify as someone who can sign off on an informal probate. So in that situation, even if you did have that power, you would need to move forward with a formal probate. You may also need a formal probate when there are no known heirs at law. So this is if someone has no heirs, because theoretically there are some heirs out there that we just don't know about, and that is the stance that the court takes. So they want it to be a formal so that they can fully investigate that. And the last is if there is only a copy of the will available. If the person died without a will, intestate, you can move forward with an informal, but if they did die with a will and we only have a copy, we do not have the original of that document, we will need to move forward with a formal probate because the judge actually reviews that to make sure that it is a true and accurate copy of the will. So the different steps that are involved are very similar to what Tiffany had mentioned with the Probate Navigator, and as was shown in that video. The first step involved is filing the documents. We file those documents to get you your initial appointment, but before you are even appointed in a formal, the court is going to issue a citation. A citation is the document from the court that basically says, give notice to all of the interested parties before a certain date and publish in a newspaper. This gives everybody notice that there is a probate happening for this person, and it gives a date by which someone must object by in the court. So It usually is about a month out from the filing, and everyone must file their objections from the court. Otherwise, after that citation date passes, we file the return citation, and the court will issue the letters of authority, which are the appointment of the personal representative. So after you receive those letters of authority and are appointed as personal representative, that is when you will enter that step 2 of the administration process that Tiffany just went over. Again, you'll gather all of the assets, pay any debts of the estate, and just keep track of everything that is deposited into the estate bank account and anything that is paid out of the estate bank account. Because once we reach the 1-year mark from the date of death of the person who we're doing probate for, we will file what's called a first and final accounting and a petition for complete settlement of the estate. This is that 3rd step that Tiffany talked about. In this, we will tell the court everything that was deposited into the account. If it was already an asset of the decedent, then it will be involved in the inventory. If it was something new that might have come up, then we will put that into the first and final accounting as a deposit into the account. And we will also tell them everything that was paid out of the estate. This can be debts, this can be legal fees, this can be fees of a personal representative, funeral costs, anything that is a proper expense of the estate will be included in that going out. And it will also have a final distribution to the beneficiaries as well. Once that is filed with the court, you then need to wait for the court to issue its final decree on the first and final account. That can take a lot of time. Formal is always a lot lengthier than informal, and everything in this just takes time waiting for the court to get back to you. Usually, formal closings go a lot faster when we have all of the beneficiaries sign what we call assents to the first and final accounting. This basically says that they approve of everything the personal representative did, they approve of the filing, and they are in agreement with everything. Usually in that case, the court is pretty quick to issue a final decree. If there are no assents, then we will have to do another citation, which involves publication and notice to all interested parties again. And that can again take more time and further lengthen the process. But the goal is to hopefully help you through it as quickly as possible. And just as a reminder, as with both probates, both formal and informal, this is a public process. We mentioned the publication earlier. However, the court dockets are public record. Anybody can go on there and find out any information they want to about the court proceedings. So this is it is a very public process. Next up is informal probate. Now, what is informal probate? It allows for streamlined administration with minimal court supervision. They move a lot faster than formal probates. How to determine when informal is appropriate? It's generally when you don't have any of those issues that we had in informal. If there is real estate involved, we may be able to open informally and close formally. Eventually, there will need to be a formal determination of the heir. So that is one situation that kind of straddles the line of both. And if there's no other issues, you could open informally, but you would still need to close formally to get that formal determination of the heirs. However, in all other situations, if the beneficiaries all get along very well, if there's no person who is lacking in legal capacity or a minor, informal probate is a great way to speed up the process, get appointed a lot faster, and have less court supervision if that is what you want for the probate. Same general 3-step process that we have. First, we file. We get you appointed as personal representative. Generally, we have you sign all of your paperwork. Then we need to serve all heirs, beneficiaries, and the estate recovery unit with notice 7 days before we file. After the 7 days has passed, we can file all of your documents with the court. They usually appoint a personal representative very quickly in this case because it is only being reviewed by a magistrate. And in fact, actually right now in Middlesex County, they are doing a walk-in informal clinic where you can go in and you can file your documents and actually receive your appointment in the same day. So that is a great option if you are looking for a very quick appointment and you know that your probate will be filed in Middlesex County in Massachusetts. After you're appointed as personal representative, We will publish in a newspaper your appointment as personal representative. This gives everybody notice that you have been appointed personal representative. They do not have the ability to object to your appointment of personal representative as they do in the formal probate. It will have to be moved to a formal probate if somebody wants to object to this appointment. After you're appointed, you go again into the same administration phase. Once 1 year has passed from the date of death, you can file what's called a closing statement. The closing statement basically tells the court that you are all done administering the estate and there are no outstanding debts of the estate. We send the closing statement to all interested parties, usually with an informal accounting, just to let them know everything that came out of the estate and everything that came into the estate. However, that does not get filed with the court. Once we file the closing statement with the court, the personal representative is free to distribute the assets to the beneficiaries of the estate. The personal representative's fiduciary duty is not terminated until 1 year after the closing statement is filed. This process is also a little bit less expensive than formal probates, usually costs less in filing fees as well as legal fees. And that's the informal probate process.
Okay, thank you, Jillian. All right, next up, you can rest your mind just a little bit, is voluntary administration. Before I talk about this, I did want to go back to something that Jillian mentioned about Middlesex County and in terms of where probate is filed. So probate is based on where the deceased person lived at their time of death. So if they were in Sudbury, for example, we go to Middlesex County. If they were in Leominster, you'd file with the Worcester Probate and Family Court. So all of the courts have it's similar paperwork, but maybe a slightly different timeline in terms of how quickly they can process things. For voluntary administration, it is the most efficient, simplified probate process available in Massachusetts. It's sometimes called small estate administration, or if you're working with a company or like a life insurance company and they say, we need a small estate affidavit, what they're talking about is the voluntary administration process. So this is available only in certain circumstances. Mostly you have to have no real estate at all, and there's a maximum of $25,000 of personal property and a maximum of 1 car. So if the probate estate is $25,000 or less and there's only 1 car, this is a really good option. And the main difference between voluntary administration and probate, there's a few differences. One is the timeline. So a voluntary administration can actually go through the court start to finish in as little as 10 days. You have to wait 30 days after the person has passed away before you can file the voluntary administration, which is a difference because with formal and informal probate, you could file sooner. Voluntary administration is more limited in scope because the person who is named is called a voluntary personal representative, and that person's duties aren't as broad as a personal representative. And that's because a personal representative through formal or informal probate is actually a court-appointed personal representative authorized to do all of the things needed to administer and close the estate, whereas the voluntary personal representative is not actually a court-appointed person. So there might be times when otherwise, like maybe there's $25,000 or less and it would work out. But a financial institution might say, we need a court-appointed personal representative, in which case we know that the simplified process isn't actually going to work out for your needs. Voluntary administration can be done whether or not the person had a will. So it's an easy solution either way. The person who's filing it is just an interested party, and they would list the assets that make up that total. So if there's a car, they'll list the VIN number in the car, and then perhaps there's a bank account worth $10,000 and maybe a collection of artwork or something else as part of personal property. But the interested party is listing that on the form. And with voluntary administration, the court actually gives the VPR the same document that was filed. It's just a certified copy that you get back. Whereas with formal and informal probate, they actually issue what are called letters of authority, and that's what you use as proof of what you can do. So just to conclude voluntary administration, it's a much more simplified process for very small estates. Sometimes it might not be enough for what you need, in which case you might end up with formal or informal probate, but it's a good starting point for estates where you can identify with certainty that there's under $25,000 of personal property. Okay. So before we get to questions, I wanted to give an overview about working with Generations Law Group and the steps that are involved. The very first thing you should know is that if someone has passed away and you are the person who is potentially going to be named as personal representative, or you just have questions about probate, you can call our office and you can speak to either Jillian or you can speak to me, have a free 15-minute phone call. We'll ask a couple questions just to get more information. Was there will or not? What are the types of assets? Important things like Jillian had mentioned, do people get along? Are there any potential lawsuits or conflicts? But basically we can gather some information from you and we can give you a sense of, are you looking at an informal procedure or do you need all of the complexity of formal probate? So the 15-minute call is a nice starting point, just so you know which direction that you would need to take. And then when we start, once someone has engaged our firm to work on the probate matter, we ask you to fill out 2 questionnaires. One of them is all about the people involved. So if there was a will, or if not, either way, we need to know the family members. Was there a surviving spouse or a spouse who passed away, or their children? Are there other people in the family? Basically, we just need to know about all of the key players who are named in the documents, or heirs if there's no will. And then one is an asset questionnaire. So we want to know what we're working with in terms of, are there bank accounts or is there real estate? Because all of those are very relevant in terms of the probate filings. We also have a new partnership with a program called Full Circle Legacy. And I'm going to ask Carol to speak a bit about that. And the ways that it can help you in your capacity as personal representative make some of this process a little bit easier to navigate.
Thank you, Tiffany. Yeah, so our new program, as Tiffany mentioned, is called Full Circle Legacy. It's an after loss advisor program. And after loss advisor is kind of a new term in this field. And it's basically someone who's just going to help you walk through all the administrative tasks. Being a personal representative includes a lot of time and a lot of effort on your part. And if the decedent was someone close to you, then you're also trying to grieve at the same time. So we would actually work really closely with the probate attorney, and that would be Generations Law Group, or even if you're working with a different probate attorney, we can work closely with them, kind of be a liaison between the attorney and yourself. We provide step-by-step guidance through all the proceedings. We can also provide emotional support during the difficult time. We create a structured approach that will allow you to fulfill all the duties. We will also serve as someone who can act on behalf of you as the personal representative. So we can kind of take a lot of things off of your plate. And then that will give you some space to process your loss. We can also help you be more efficient in the administrative tasks. As I mentioned, there's a lot of time that's spent being a personal representative. I think the average is around 500 hours. It could be up to 700 or possibly more. And as Jillian was mentioning, some of the probate, if it's a formal one, it can take a lot longer. So it takes a lot of your time and effort. So we can help take a lot of that off. We can also help with the family dynamics. We can help you communicate effectively with the beneficiaries, set appropriate expectations and timelines, and navigate difficult conversations with them. And we can give you accountability and progress tracking. So we can help you provide regular check-ins so you can track your progress, ensure that some tasks don't fall through the cracks, while giving you the peace of mind that you're fulfilling all your responsibilities. And as I mentioned, so we have two programs in which we can do this. The first program that we have is the Inner Circle program. That's where we act as an advisor, and we create a structured program for you so you know what you need to do and when you need to do it. And we check in with you regularly as much as you need. So you do all the administrative work, but we are making sure that things are getting done, keeping you accountable if you need it, and help you track your progress. We can also, if you're hitting roadblocks, we can help you navigate those roadblocks. The other program is called the Extended Circle program, and that's where we would act a little bit more as a proxy, where you need to do your full-time job, you need to take care of your family, you don't have as much time to take on all of those administrative tasks. So we would do as much as we can in your place for you, and we would check in regularly so that we would keep you up to date on what's been done, what needs to be done. And we could act again as a liaison with the attorney, with financial advisors, and keep that on track. So if you feel that you want a little extra support while you're going through the personal representative process, we can also help people who aren't necessarily serving as a personal representative. Sometimes you don't need to go into probate and you just need to take care of a few administrative things. If you need help with that, we can assist with that as well. If you have any questions about the program, give our office a call or call me directly. And we'll post the number at the end of the video so you have all that information.
Thank you, Carol. It sounds like a really amazing program. All right. So next up, we have some questions in the chat box that Carol, I think, is going to read to us. So go ahead, Carol.
Yes, we do. We have some. So the first question that came up is, what about my car? How does that get handled?
That's a good question. So your car can be handled as we say that your car is the least of your worries. So we don't want you to overthink it. If your car has a joint owner and you pass away, then the surviving owner owns the car, so it wouldn't be a probate asset at that time. For a surviving spouse who is going to inherit a car if it wasn't jointly owned, you can go to the RMV and fill out a form and provide a copy of the death certificate and get the car transferred into your name. Something to be on the lookout for, though, is that if you have an outstanding loan obligation on your car, that will have to be repaid before you're able to transfer the title fully. If you don't have a surviving spouse and there's not a joint owner on the car, so you have just a car outright in your name and you pass away, it becomes a probate asset. So if it's part of voluntary administration, it could be taken care of by that voluntary personal representative in that simplified proceeding. Otherwise, it would just become part of formal or informal probate. So it just depends on, is there a joint owner, is there a surviving spouse? But ultimately, it's always possible to get it transferred over once someone has that authority, whether from the court or the surviving spouse.
Okay. Thank you. Okay, so I just want to make sure. So if there is a surviving spouse, they can go to the RMV and have it transferred over, but the car has to be paid in full in order for them to do that. Okay.
Yes, yeah, there has to be clear, clear ownership, clear title of the car to be able to transfer it out.
Okay. Excellent. Another question that's in the box here. What about joint assets? How does that get handled?
Joint assets are generally not a part of the probate process. Anything that goes into probate is either, so if there's a joint owner or if there's a named beneficiary, then it does not pass through probate. Some people are put on their parents, aunts, uncles' accounts for convenience purposes, so they can help them manage their own assets. And some people prefer for that to go through probate just so there's a clear transaction of the account and what came in and what came out of it through that process. However, there is no requirement by the probate court or the bank to probate that account.
Okay. But so on joint assets, like say a bank account, you could put like a beneficiary though, right?
Yes, yep. You could also put a beneficiary on a bank account. I believe if it was a joint owner bank account and there was a beneficiary, then it wouldn't pass until the other owner had passed away. But if it was just your own bank account and you put a named beneficiary on it, then it would not pass through probate.
Okay.
You can do the institution will tell you the options, but there could be a beneficiary. It might be a pay on death or it might be on a transfer on death. But it's always a good idea, going back to that question I had said at the beginning of when I die, what will happen to this? Is there somewhere for it to go? And so if it's not joint, or if it is, the survivor would want to have one of those backup plans.
Okay. Thank you. Next question. Do I need to include life insurance?
Great question. So this goes back to that idea if there's not a named beneficiary on the life insurance, or if the named beneficiary on the life insurance has predeceased the person who owned the life insurance policy, then it would have to go through probate. Usually these have a beneficiary named on the policy, so they don't go through probate, but it can happen every now and then, again, where the person has predeceased them, and then it does become a probate asset, part of their estate.
Okay. And then next one is, what if I do voluntary administration and then we find out about more assets after?
That's a good question, and it does happen from time to time. If you've done voluntary administration and you find out that there are more assets, or sometimes someone will take their voluntary administration statement to the bank, and the bank who wouldn't disclose information before will say, actually, this isn't good because all we can tell you is that the estate has, or the account has more than $25,000 in it. The next step is basically then to just go and move forward with a subsequent action, which would be informal probate or formal probate, depending on the assets and the circumstances. So you could start with voluntary and later find out that it wasn't actually what you needed. And then you just move forward with a formal probate proceeding, whether formal or informal, but an actual probate proceeding.
Okay. And would you guys at Generations Law, would help, you would help me do that if that were the case?
Yeah, we can help you pick up from where you were and get it all situated with the court. Yeah,
Okay.
absolutely.
Okay, great. And then the last question is, when does the personal representative need a bond or sureties?
Okay. So that's a good question, and it has a long answer.
Okay.
So, so what bond? So bond is your promise that you're going to do everything appropriately. There's not going to be any fraud or misconduct. Sureties on bond are basically like an insurance policy that say, okay, like I as personal representative have this insurance policy that like I'm going to do everything right, but if I mess up, there's sureties, this guarantee that everything will be corrected with the estate because we have this like this promise that someone else is basically going to be accountable for my mistakes. So it is essentially like getting an insurance policy. So our goal for most people when we're creating an estate plan and preparing a will is to have the will say we're waiving the requirement for sureties on bond. So we can tell the court when we're filing everything, there are no sureties on bond for the personal representative because the will says so. Jillian mentioned the assent forms before indicating agreement. We also would like all of the interested parties to sign an assent saying, we agree to this petition, whether it's for formal or informal, and we also agree with this waiver of sureties. So, so you don't need bond if it's expressly waived in the will and if everyone agrees and says, yeah, we don't need this. If there was any conflict or a beneficiary or interested person said, oh, I have some concerns about this, then the court might say, okay, we actually think that you should have sureties on bond because not everyone agrees, or someone's raised a reasonable objection within the time frame to present objections. So you actually have to have these sureties on bond. And then instead of a bond without sureties, you could either have a corporate bond or you could have personal sureties. A corporate bond you would get through an insurance company, whereas a personal bond would be two disinterested people would say, we're guaranteeing this amount It's called a penal sum, and that's based on personal property. So if there were $500,000 in personal property, bank accounts, etc., in the probate estate, either the corporate bond would cover that amount, or the two people who were signing on your behalf would cover that amount. So again, if it's not waived in the will, if there's any disagreement, not everyone agrees, then the judge might think it's in the best interest to say, we are requiring sureties on bond for this personal representative.
Thank you. That was helpful. I think that's all the questions from chat box today. Do you have any other questions that have come up for you? No. Okay.
No.
All right. Well, I guess that's everything. So thank you so much, Jillian and Tiffany, for this information about probate and the different types and for answering our questions. And I wish everybody a great afternoon.
Thank you.
Thank you.
Bye.